Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe, and I am back tonight as scheduled to talk to you about obtaining permanent residence and permission to work authorization in the United States. Ways that you can do this. I'm going to give you a general overview of ways that you can do this, especially if you are in the United States and you're trying to figure out how to go from being where you are, whether you're here and you don't have your papers or you have your papers, and then how to get to permanent residence in the US and how to get permission to work. But keep in mind that you can also put your questions in the comments. It can be anything that's immigration related. Now, I want to formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their status and their status, work permit, and work permit, as well as permanent residence in the United States. So if you are going through the immigration process, you're thinking about going through the process, or even if you've been through the process and you have questions, go ahead and put those questions in the comments and I will answer your question. So how do you obtain permanent residence in the US? So you have to qualify through some means. So I get the question often, can I have a visa? Or can I be in the United States just purely, over time, can I obtain permanent residence? Or I have a visitor's visa, I'm visiting and I want to stay. How do I go from visitor's visa to permanent residence? And my answer is always, well, how do you qualify? And that's where the consultation is very important, because that's where we're really going to delve into your circumstances to determine what is the best path for you, whether you have options to get permanent residence and permission to work in the United States. So you generally, you can qualify for permanent residence in different ways, so many different ways, but I'm going to give you the most common ways. So through an employer, the most common way to come to the United States is through family. So not only through marriage, but also through parents, through siblings, also through a U.S. citizen son or daughter who's 21 and up. So TugTug 1981, awesome. That gives me a great joy to hear that your interview went well. Thanks so much for telling me about that. So now when you're, so you can qualify through an employer, through family, which is the most common way. Also through a humanitarian means. So if you're in the US, you already have a T, a U visa, or you've received asylum, that is a possible way for you to qualify for permanent residence. And then there's also that last effort, if nothing else works, if all else fails, you don't have any connections to the United States, no relatives, no employer, no humanitarian, so no asylum, no T or U visa, there is always the lottery for the green card. I call it the lottery for the green card. And so when you do that, the Department of State maintains a website. They open it up every October. You can go there, sign up. Hi, Dee, it's nice to see you. Thanks for saying hi. You can sign up. And once you sign up for it, you could have a chance at obtaining permanent residence. If you are selected, you're assigned a number, and if your number is processed before a certain time, you can become a permanent resident. Most times it's done through consular processing, meaning you can be outside of most people apply from outside of the United States for this, and then they go through to the interview at the embassy and then come to the United States as permanent residents. So those are 4 main ways to obtain permanent residence. Now, if you're here without your papers and you're trying to figure out how to fix that situation, to go on, to get permission to work, to get status, to be able to get permanent residence, how can you do that? So the main thing is, once again, how do you qualify? And so my next question is, if you are here, do you qualify for adjustment of status? That means to apply while you're in the United States. Or do you qualify for a waiver that will help to fix the situation and then help you to still go on to get the permanent residence? And so for the time that I'll be here, I'll be focusing on those two different processes and who qualifies for what. However, keep in mind that I'm here to answer your questions. And actually, sometimes your questions can help me to explain, put some of what I'm trying to explain into context, apply it to real world situations when you have a question. So don't hesitate to put those questions in the comments. Also, I am going to be here from now on. I know before, I was here at different times of the day. I have finally set a particular time to come, and it's going to be 9 p.m. every night with very few exceptions. So keep that in mind, but I will be here at 9 p.m. every night. So go ahead and put your questions in the comments. Now, I'm going to go ahead and focus on those two ways. So one, through adjustment of status, can you qualify for and obtain permanent residence through adjustment of status? Or can you do it through a waiver if you can't qualify? So who qualifies for adjustment of status? Now, only certain individuals qualify for adjustment of status. And so it's important for you to know whether you qualify, because that is really going to help you to decide whether you need to now in every and all situations, you should definitely seek legal advice. But this is going to kind of guide you a bit, give you some information about what you could possibly be looking at in the future. But to confirm this, consultation is essential, because this is general information. It is not personal legal advice. So who qualifies for adjustment of status? And when I say adjustment of status, I mean who qualifies to apply for permanent residence while staying in the United States. Now, so Vicky T21, go ahead and put your topic in, and I would gladly elaborate on it. Now, with this, so if you live in the Caribbean and an employer wants to employ you, how they go about it? So usually they would, follow their usual process, but once they hire you, or they give you an offer rather, because sometimes they will give you an offer if you're not already employed by them. You would use that to then apply, and the employer, usually it's the employer that has to file the petition. And so the employer is the person that would work with me to prepare the documentation and move forward with the petition. But how the process works really depends on how you qualify, what kind of employment-based permanent residence or even visa are you pursuing. How long is it taking to get an interview now? So I can't tell you how long it's taking to get an interview, but I can tell you how long on average. This doesn't mean that's going to be the case for you that it's taking. It's taking about 18 to 24 months if this is marriage-based. If this is any other, so marriage-based, based on marriage to a U.S. citizen. So me and husband applied and I did my fingerprints, but still haven't received my interview date. So yeah, so even though you did your fingerprints, you could be looking at the interview so it's taking about 9 months to 18 months for the interview, and the entire process is taking 18 months to 24 months. So prepare for it to be that long. If you applied for a work permit, that may be the next thing that comes, and it may provide you some relief while you wait. So look out for that, and just make sure that they're not asking for anything on your end, that everything is good. So Vicky Tick, you're welcome. So my husband, I think that's I-130 petition is filed, and my husband have visitor's visa. Can we change that status when he comes here? So that could be a possibility. Now, your husband cannot be entering the country with the intention of coming to adjust status. Because remember, when he's coming in with a visitor's visa, he has to be coming with the intention of staying temporarily. Another thing, Fafe, that you have to keep in mind is the risk. Now, with a pending I-130 and your spouse coming in with a pending I-130 that it may be close to an interview, an officer may very well turn him around and conclude that he has what's called immigrant intent, and that can actually complicate his process. So once you're in the middle of the process, sometimes it's best to stay, wait it out, and wait for the entire process to pass. Unfortunately, I know that there's separation, but there is that small risk. While I can't tell you what to do, I can't tell your spouse what to do because I'm not your attorney and I can't provide you personal legal advice, I can tell you that there is that small risk that when they're coming in, they could face some pushback and even be turned around at the border. I filed the I-130 online and still haven't heard anything. Can I file for the work permit now? So Mocha, it really depends. This is where you have to schedule a consultation because you're already in the process. You already filed the I-130. I'm not even sure if you can file for the work permit. What type of application are you filing? Now, where you usually apply for the work permit is when you're applying for adjustment of status. Does your spouse qualify for adjustment of status? That's mainly what I'm talking about here because it's so important to tell the difference between the two. Not everyone that qualifies through a spouse or a relative qualifies for adjustment of status. Only those adjustment of status and a work permit in the US. Only certain individuals. Those individuals are going to be those who are currently maintaining status in the United States. And so they can maintain status for the duration of the process here. And immediate relatives of US citizens who came in, inspected, were paroled, or given permission to come through the border, at the airport or the border. And so it's very important to first determine whether you qualify for adjustment of status. Once you qualify, you can submit the adjustment of status application along with a work permit application. But it all depends, and that's where it's very important to get legal advice. What you need to do, schedule a consultation. My phone lines are open 24/7. And then you call now to schedule the consultation, and after hours receptionist will take your name, your information, and then a scheduling coordinator will get back to you on the next business day to schedule your appointment. And you live in New York, so I am located in Boca Raton, but keep in mind I represent clients all over the country and the world, so that will not be a problem. I can advise you on this and possibly help you through the process. Because how you're going to approach this work permit is really going to depend on what are the circumstances. Does your spouse qualify for adjustment of status? What is your status? Are you a permanent resident? Are you a U.S. citizen? Did your spouse come in inspected? So keep that in mind. Can I sponsor my dad and stepmom as a citizen, but I just sponsored my husband? So Cassie, generally speaking, yes, but where you have to be concerned is, can you sustain, can you provide an affidavit of support to show that you can support, so at minimum, a household with your husband, your dad. Your stepmom is really going to depend on, as a U.S. citizen, your stepmom cannot be included in the application with your dad. However, your stepmom, if you are married before your dad and stepmom got married, and you were under 18 at that time, she would qualify as your stepmom, and you could apply for her as a parent separately. So very important. Once again, this is general information. Very important that you get legal advice. But there are no restrictions on how many immigrants you can sponsor at one time. But you do have to make sure that you can show that in the affidavit of support, you have the income that's required. If not, you can always get a joint sponsor as well to help to make up for that income if you don't have. And now to find the income requirements, you can go to uscis.gov, uscis.gov, and go to I-864P. Just type that in the search. It's going to bring up a chart with the income that you should be having for the number of people in your household. Can I file asylum and work permit at the same time? So not necessarily. There is a time restriction on the asylum, and so you have to be careful with that. So it all depends on your timing. Kimmy Meme, thanks for sharing. Can I file for my son, and how long is going to take? So now, Dark Horse, it depends on what your status is. And it's nice to see you, by the way, Dark Horse. So if you are a U.S. citizen, you can file for your married son or your unmarried son. But keep in mind, it's better to file for your unmarried son, because your unmarried son will, it takes a shorter time, but still a long time. Right now, it's taking between 6 to 7 years for unmarried children over 21 to be sponsored by a U.S. citizen. If you're a permanent resident, it's taking 5 to 6 years for unmarried children only. My husband is the U.S. citizen. Okay, so Mocha. So I'm sorry, your question. Okay, so the U.S. citizen. So if your husband is a U.S. citizen and you're here, you are here and you qualify for adjustment of status and you have the receipt notice, then you can move forward with applying for adjustment of status, generally speaking. However, keep in mind that I noticed you said you haven't heard from them. You want to make sure that you are going about the process correctly. In my case, is in Kingston, didn't do anything there yet though. Is it very long wait to start? So child of faking, it really depends. So it depends on what process you're going through. So can you clarify who is applying for you and how long have you been waiting? Why does a resident have to wait until he or she becomes a citizen before sponsoring a spouse who overstayed? So great question, and I'm glad you brought this up, because this is so very related to what I want to talk about. Now, they don't have to wait. However, it may be better just depending on your circumstances. So if you have a resident spouse and say the person just turned into a permanent resident, and then you just got married after they became permanent residents. Now you are separated, or you are in the country and you're out of status, and your spouse is looking at another 4 years or 4 years and 9 months to be able to apply, and then another 6 months to actually become a citizen. That's a long time. In a case like that, your permanent resident spouse can actually still apply for you. There is a process that is available when the spouse has overstayed, and that's the waiver process. Now, if you have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardships if you don't get the green card, you can apply for this waiver. This because a spouse of a green card holder who's out of status does not qualify for adjustment of status, and since they've overstayed, and they probably overstayed over 180 days, they can't leave the country, right? So they're in a tough spot. Can't leave the country to attend a green card interview, can't adjust status through a permanent resident spouse. What to do? This is where the waiver can work, especially if you're looking at 5 years until you actually become a citizen. It's worth pursuing this waiver process. Now, as the resident spouse, you'd have to show that you will experience extreme hardship if your spouse doesn't get the green card. But once you have shown this and the waiver is approved, once the interview is scheduled, your spouse can then go to their home country and attend the interview and not face the consequences of the overstay. Now, the way that this process works is first the resident spouse will still go ahead and file the petition to sponsor their spouse. Once it is approved, then it's going to go to the National Visa Center. But the most importantly, now you know you need that waiver. So you will attach the approved petition to a prepared waiver. Now, this prepared waiver is not just a fill in the blanks form, so don't underestimate it. That's the worst thing you could do. It is a type of waiver that you have to make sure that you have legal know-how, you understand what you're in for, you gather the evidence, sufficient evidence. It takes a lot of strategy and coordination. However, once a good waiver application is put together and if it's approved, then your spouse can go ahead and finish the process and still get permanent residence. And all of that can still be completed in less time than it would take for you to get the citizenship. Now, worst comes to worst in a situation like this, if you don't get approved for the waiver, you then could know, okay, your only option is for your spouse to go and get citizenship. But that is a good question, and thanks for asking. So my dad is applying. It's been 7 years now. Got the letter earlier this year from U.S. Immigration. Yep. So just make sure that you follow all their instructions. Keep in touch with the National Visa Center. Make sure you submit all the documents that they're requesting. I wanted to also ask about spousal visa for my husband, but he's in withholding status. Don't know what. So this is going to be a complex issue, very complex issue, because usually those who have withholding can't just go from withholding status to permanent resident. There has to be a process in between. Sometimes it takes going back to the court and getting it reopened in order to make things right, to finish the process at the USCIS. So Ashna, get legal advice. There may be ways, but you want to make sure that you get legal advice because it's a very complex situation and it really depends on all the facts that were involved. Because even with withholding status, what other issues are in your spouse's background that could or couldn't prevent them from getting permanent residence still? I just got married to a green card holder husband. I overstay. What's the next step? So now if you just got married to a green card holder spouse, you need to get legal advice. There are different options here. So, adjustment, if you overstayed, adjustment of status is likely not going to be an option. Unless, keep in mind that you just got married, so this may not be the case. But just in case anybody here is listening and they can relate to this, if you are being mistreated by a green card holder spouse or a U.S. citizen spouse, there are ways to still apply and adjust status in the United States. So this is one situation where you could have a green card holder spouse and adjust status if that spouse is mistreating you, if they're refusing to apply for your permanent residence, if they have been subjecting you to verbal mistreatment, physical, but it's not required to be physical, emotional, even financial, right? This is a way to adjust status. However, if you are not in a situation where you're being mistreated, but you are with a green card holder spouse, and you're with a green card holder spouse, there is what's called the waiver process. However, if your green card holder spouse is, say, 6 months away from U.S. citizenship, it might just be worth waiting for them to be U.S. citizens. And this is where it's very important to get legal advice, because you want to make sure that you are evaluating your options based on your circumstances. How long will your green card holder spouse take to be a citizen? If it's going to take a long time, then maybe it's better to pursue the waiver process, because if your spouse is looking at maybe 5 years until they become a U.S. citizen and you have no other way to qualify, then the waiver process could take a shorter time than the 5 years. And actually, Green card holder processing time for green card holder spouse is shorter than it was because there is currently no wait list for spouses and children under 21 of green card holders. So what that means, usually when a green card holder is sponsoring their spouse or children, they have to wait for an immigrant visa number to become available. However, in this case, it's current, which means there's no wait list. There are more immigrant visa numbers than there are applications right now. That can change at any time. And so that's why I say, if you're going to go ahead and try to apply through your permanent resident spouse, whether you're outside of the United States or in the United States, it is a good time to really evaluate your options. My mom is a citizen and she applied for me and my son. How long is that going to take? So you're looking at about 6 to 7 years right now if you're over 21 and unmarried. If you're married, that you're looking at about a 12 year process, unfortunately. That's the reason I had to overstay. So you overstayed. Diana's, I can't stress enough, get legal advice. There are options. And so you want to make sure you evaluate these options, because you, even as the spouse of a green card holder who overstayed over 180 days, you will not overstaying will disqualify you from adjustment of status. And then at the same time, once you get over the 180-day mark of being out of status, you are at a point of no return, because if you leave the country without getting this waiver approved, you're barred from ever coming back to the country for 3 years at minimum, 10 years if you overstay over a year. So very important. Hi there, Kayla, it's nice to see you. King and Baby Doll, hi there. If someone is over 18, can they be sponsored by a step parent? So yes, they can, but keep in mind, where you can be sponsored by a step parent is if you were under 18 at the time that your step parent and your biological parent got married. If that's the case, your U.S. citizen step parent can actually file for you as like a child. As long as you're under 21 and unmarried, you will have priority in the process. So think about that. Get legal advice. Make sure you act on it. Schedule a consultation. Call. Now you can go to the link in my bio, go to the website where you can get the information on the website, complete a contact form, because if you're looking at a possible being sponsored by a step parent and you're still under 21, this could possibly be a path, but it depends on your age at the time they got married. In order to qualify through a step parent, you had to be under 18 at the time they got married. I'm out of status and overstay my fiancé visa. My sponsor did not file adjustment of status. So I'm so sorry about that. And Felix, it really depends. Did you get married? So did you get married to your fiancé, and then did they still, because the only time that they could file adjustment of status for you is once you get married. So if you overstayed your fiancé visa, then that is definitely going to require additional information to see what your options are. There may be additional options. However, if you're not married, it may not necessarily be a direct path. So you may not be able to apply directly for permanent residence, but there may be other options just depending on what this fiancé put you through, why they didn't file for you. So important to schedule a consultation and determine if you got married, then the next step would be to determine what happened in your relationship and can you move forward on your own to be able to file based on the treatment if they mistreated you. My mom is a green card holder and I'm 33 and divorced. How long will it take if she sponsored me? So 5 to 6 years. Now I am going to go over to Instagram right now. I have scheduled a live on Instagram at 9:30, so I am heading over there. You can join me if you're on Instagram. We can continue this conversation. So hop on over to Instagram. I'm the same name here. So same handle, The Immigration Attorney. If you know that you need personal legal advice, go ahead and call 561-405-4889. Schedule a consultation. My videos are plastered all over my videos, and you can go to the link in my bio. Or just continue this conversation, hop on over to Instagram. I'm going to be on Instagram. Again, thanks so much for the gifts. I appreciate that. Hop on over to Instagram. Let's continue to talk. I know I have to go over there because I have a scheduled live there. So you have another possibly half an hour to come and ask your questions there. All right. See you tomorrow at 9. If I don't see you on Instagram, remember I'm at The Immigration Attorney on Instagram. Follow me and hop on. All right. See you soon.